Unilaterally announced his position to other commissioners at an unannounced meeting was found to be violative.
Oh, an unannounced meeting.
Right.
Correct.
And he just unilaterally announced it. There wasn't a response back to him, as I understand it. That's what it says on the website. That's how I read it. And the First District Court of Appeal, per curiam, affirmed that circuit court ruling without opinion.
Right.
So there is, I think, a very real live issue here. Because there's a real live issue, I would encourage you and everyone not to regard this as an ad hominem attack, but to regard it as raising of an important legal issue. And I view it that way. And in that sense, let me also give a bit of a sermon myself. Our legal system, at least at present, is an adversarial one. And that truth model is that if two sides are pitted against each other and they're adversaries, that something closer to the truth will arise or be discovered, be found. And that builds on something very ancient. The Hebrews actually thought that engaging in a dialectic moved one closer to the truth, where the sides would come together. That's not a bad thing. That's not an ad hominem attack. There needs to be vigorous debate and discussion. So I think Mr. Kosin has raised important issues. I independently raised them myself. And what we need to take away from this is that this body has got to be, needs to be beyond reproach, not flying close to the flame, because then it begins to shade into our work product, and we don't want that to happen. As you say, we want to stay focused on the substantive work product itself. That's how I view it, not necessarily ad hominems, and a serious issue and one that does need to be addressed and discussed.
I would agree wholeheartedly. There have been dialogue, discussion, debate, but when the law is clear that a council member can present a position as long as there's not a dialogue, a discussion, a debate, or a decision on the issue, the law is clear. And the first that I've heard about that was this accusation. And he didn't focus on the issues of what we were doing. He made a false accusation because he said we violated and we have no excuse of ignorance because we're lawyers. And I went and looked at it, and I talked to the Attorney General's office. I read every one of those Attorney General's opinions, and that's why I read the memorandum. Yes, it was a little bit closer. We need to stay away. I have no disagreement about that. But the discussion first and foremost was not what are they recommending, what are they talking about, what's going on. And in that draft, as I explained in the memo, she sent me a draft. I went because her husband was helping her type it up. You know, I've been in the business a long time. I just make clerical correction, no substantive corrections. There were some notes to it. And that is what went to all of us, and we discussed it. There was no direction, correction of substantive issues or something like that. I take out 2 periods, I make it 1 period. There was a lowercase a, I made it an uppercase a. And so there was no discussion, no deliberate discussion. If anybody had taken the time before they accused somebody of her position, my position, or Ed Fleming's, of substance, of violations of that sunshine law, and read what she sent and read what was sent out later, there was no substantive discussion that's going on. And the difference is, and the problem is when you get to this commission, because if you go on what Benjamin Franklin did after this, when he saw what was going on, is he said, let's take a 3-day recess and let's gather and discuss and become friends for those who are on each side and on each from the big states, the little states, the Hamiltonians, and the other folks. And unfortunately, in this process, we can't do that. So there's not the time to heal or talk and whatever and discuss. So I agree with the sunshine law. I agree it needs to be in the public. But to bring out these accusations, unless there is clear proof of it, what I understood from the old principles of false witness is you don't accuse somebody of a crime unless you're clearly believe that a crime occurred. And we got accused of criminal behavior.
Which, in our professional capacities, is defamatory.
Right, and I'm not here to defend Mr. Kosin. I to talk about the process. I would state for the record, I think he said that there were apparent violations, so one can interpret that as
And he had talked
violations.
to an attorney, and the attorney agreed to it. So there's enough wiggle room in it, but the essence of when you come through is a former justice on the Florida Supreme Court, Florida County attorney, and a former attorney who know better violated the Sunshine Law and were acted untoward.
And the issue is, and he did, as I said, I'm not here to defend Mr. Costin, but for the record, he did set forth what the emails were, and the issue is, what do they constitute discussion? I mean, it begs the question to say they don't. Obviously, that's your...
He said they constituted discussions, and there were no discussions.
Well, I
A
think
discussion
your
is a
position
dialogue,
is
and there was no dialogue. There was a question rendered and no response. That's a monologue, not a dialogue. And the prohibition is against the dialogue. And it's appropriate to ask a question as long as there's no discussion, so when we have a drafting committee meeting, that we can discuss it at that meeting.
I understand what you're saying. I think there's legitimate disagreement here, and I would just encourage all of us to not take it as an ad hominem attack. I think, however, the most serious thing he said was it's no accident, and I agree with Ms. Lander, that implies intent, which would render actions criminal.
Right.
But, and let me just say with respect to history, I think John Adams and Thomas Jefferson forever remained at battered points and still were able to accomplish great things for the country. So some good can come out of this, I hope. Thank you, Mr. Chair.
Well, first of all, Mr. Bell and Ms. Lander, I hope that you do not take my reports as a criminal accusation. I did not mean it in that way, and the Sunshine Law is a complex statute, and it's very well possible that whatever violations may have taken place were unintentional. So I didn't mean to make a criminal accusation, but it is apparent, based on those emails and some other discussions, that certain members of this board are not as familiar with the Sunshine Law as they could be or should be. So I wanted to just read a little bit from the Government of the Sunshine Manual. It's very clear and corrects some of the, I'll say, misunderstandings that Justice Bell made in his memorandum. Specifically in one area where he said, essentially, two members of a board can meet privately to interview a consultant, for instance, and discuss matters. That's not the case. They cannot. Bottom line, board members cannot discuss any public business in private if it is not properly noticed. And that's laid out in case law and statute.
I think it was correct. If you remember, that was simply a quotation from the Florida jurisprudence. It's not a quote from me.
Well, sure, that's fine, but you were representing it as the case, and I just want to make sure everyone understood that it is not the case. You cannot meet in private with any other member of the board to discuss any business that may foreseeably come before the board. That's just the law. Now, Times Publishing Company versus Williams, 1969, established that, quote, every step of the decision-making process is, quote, an official action. Now, the statute 286.011 defines official action, or says that any official actions must take place at properly noticed meetings open to the public. So, bottom line, every step of that decision-making process needs to take place at a properly noticed public meeting, and that includes discussing issues among consultants. That includes drafting charter documents. That includes all of that. That is all business that may foreseeably come before your board. And I wanted to just read a little passage specifically addressing electronic communication. That is, obviously a new, burgeoning technology that a lot of people don't understand the Sunshine applications already in. As discussed in this manual, the Sunshine Law applies to the deliberations and discussions between two or more members of a board or commission on some matter which foreseeably will come before that board or commission for action.